I was standing on my brand new composite deck, admiring the way the morning sunlight caught the grain pattern, when I saw her marching across my lawn like a general preparing for battle. Sharon Westfield, president of the Meadowbrook Heights Homeowners Association in Charlotte, North Carolina, had a clipboard in one hand and her phone in the other, already taking pictures before she even reached my property line. "Logan Callahan," she called out, her voice sharp enough to cut glass. "We need to talk about this." She gestured dramatically at my deck, which I'd spent the last 3 months planning, permitting, and building with the help of a licensed contractor. I set down my coffee mug on the new outdoor table I'd just assembled. "Morning, Sharon. Something wrong? Wrong? This deck is at least 3 feet too close to your property line." She tapped her clipboard with her pen, the sound like a woodpecker attacking aluminum siding. "The HOA setback requirements clearly state that all structures must be at least 15 feet from the rear property line." I felt my jaw tighten, but I kept my voice level. "Sharon, I followed every rule in the HOA handbook. I submitted my architectural review application back in January, got approval in February, pulled the proper permits from the county, and built this deck exactly according to the specifications that were approved. It's 12 feet from the property line, which was the requirement when I submitted everything." She shook her head, her blonde bob not moving an inch despite the spring breeze. "That may have been the old rule, but we updated our guidelines last month. All structures now need to be 15 feet back." "Last month? Sharon, I broke ground on this deck in March. It's May now. The deck's been finished for 2 weeks. Nevertheless, you're in violation of current HOA standards." She made another note on her clipboard. "You'll need to either move it or tear it down and rebuild it in compliance." I stared at her, genuinely wondering if this was some kind of elaborate joke. "You cannot be serious. I have all the approvals. I have emails from the Architectural Review Committee. I have county permits. Everything was done by the book." Sharon's expression didn't change. Her face had that particular look that middle-aged women who've discovered a tiny amount of power sometimes get, like they're personally responsible for maintaining civilization itself. "The rules have changed, Logan. Everyone needs to comply with current standards. You have 30 days to come into compliance or we'll begin levying fines. $500 per day until the violation is corrected." She turned on her heel and walked away before I could respond, leaving me standing there with my blood pressure rising and my peaceful Saturday morning completely destroyed. I pulled out my phone and immediately started scrolling through my email history, finding the entire paper trail of my deck application. Every single document showed the 12-foot setback requirement. Every approval email referenced those specifications. My wife Dana had left the previous month for a 6-month nursing contract in Seattle, specializing in trauma care at Harborview Medical Center. We'd discussed it extensively before she took the assignment. The money was exceptional, and we were saving for renovations on our 1980s ranch house. She'd been excited about the deck project, and we'd video chatted almost daily while I was working on it. Now I had to call her and explain that the HOA president wanted me to tear down the $5,000 deck I'd just finished building. "That's absolutely insane," Dana said when I explained the situation over FaceTime that evening. Her dark hair was pulled back in a ponytail, and I could see the exhaustion around her eyes from her 12-hour shift. "You have all the documentation. They can't just change the rules and apply them backward." That's what I thought, but Sharon seemed pretty confident. "I'm going to call Rick tomorrow and see what he thinks." Rick Newsom was my attorney friend from college who'd moved to Charlotte around the same time Dana and I had relocated here 5 years ago. He practiced real estate law, which suddenly seemed like exactly the expertise I needed. Rick met me for lunch on Monday at a barbecue place downtown, away from the neighborhood where Sharon seemed to have informants everywhere. He reviewed the documents I'd printed out, occasionally making notes on his legal pad. "This is pretty straightforward," Rick said, setting down a document. "They approved your deck under specific guidelines. You built according to those guidelines and got your permits based on those approvals. They can't retroactively apply new rules to a structure that was already approved and built." That's what I figured. But Sharon was acting like she had the law on her side. Rick shook his head. "HOAs can be tricky because they do have a lot of authority over property use within their jurisdiction, but that authority isn't unlimited. What they're trying to do is called retroactive or ex post facto enforcement, and courts generally don't allow it. You relied on their approval in good faith, spent money based on that approval, and completed the project according to spec. They can't move the goalposts after the game is over. So what do? First, you're going to write a formal letter to the HOA board citing your approval documents and explaining that you built in compliance with the rules in effect at the time. Reference the specific dates and the approval you received. Tell them you will not be removing or modifying the deck because it was built legally and with proper authorization. Keep it professional but firm. And when they start fining me $500 a day? Rick smiled grimly. Then we file suit for declaratory judgment and injunctive relief. We'll ask the court to declare that your deck is compliant with the rules that were in effect when you built it and to enjoin the HOA from collecting fines. Given the facts, I'd say we have a very strong case. I spent that evening drafting the letter Rick had suggested, with his help via email as I wrote and revised. By Tuesday morning, I had a professional, detailed response that laid out my entire timeline, attached copies of all approvals and permits, and clearly stated my position that the deck was built in compliance with applicable rules and would not be modified. I sent it via certified mail to Sharon at her home address and to the HOA's registered agent address. The response came faster than I expected. On Thursday, I received a formal notice of violation in my mailbox, printed on HOA letterhead with Sharon's signature at the bottom. It repeated the claim that my deck violated current setback requirements and stated that fines would begin accruing on June 1st if the violation was not corrected. The letter made no acknowledgement of my detailed response or any of the documentation I'd provided. "She's not even pretending to consider the facts," I told Rick over the phone that evening. "It's like she didn't read anything I sent." Some HOA board members get it in their head that they're right, and no amount of evidence will change their mind, Rick said. "The good news is that this kind of unreasonable behavior tends to look very bad in front of a judge. Go ahead and let them start the fines. We'll include those in our lawsuit and ask for attorney's fees and costs as well." June 1st came, and so did another letter from the HOA. This one informed me that I was being fined $500 for each day the violation continued. A separate notice stated that if the fines weren't paid within 30 days, the HOA would place a lien on my property. I called Rick immediately. "They're going for a lien, expected. Let's file the lawsuit. I'll get the paperwork started today." The complaint Rick filed in Mecklenburg County Superior Court was thorough and devastating. It laid out the entire timeline in meticulous detail, attached every email, every approval document, every permit, and every photograph of the deck construction. It asked the court to declare that my deck was built in compliance with applicable HOA rules, to void any fines imposed by the HOA, to enjoin the HOA from placing a lien on my property, and to award attorney's fees and costs. The lawsuit hit the HOA like a thunderclap. Within 2 days of being served, I received a phone call from Deborah Morrison, the HOA's vice president, who I'd always found more reasonable than Sharon. "Logan, I think there may have been a misunderstanding," Deborah said, her voice careful. "The board would like to meet with you to discuss the deck situation." "There's no misunderstanding, Deborah. I built my deck according to approved plans and existing rules. Sharon decided to apply new rules retroactively. Now I have a lawsuit filed because the HOA refused to acknowledge basic facts. I understand you're frustrated. Could we at least sit down and talk about this? Maybe we can find a solution without going through expensive litigation." I thought about it for a moment. "I'll meet with the board, but I'm bringing my attorney, and I'm not agreeing to modify or remove my deck. If the board wants to acknowledge they made a mistake and drop this entire thing, I'm willing to listen." The meeting was scheduled for the following Tuesday evening at Sharon's house, which served as the informal HOA headquarters. Rick accompanied me, carrying a briefcase full of documents. We were shown into Sharon's dining room, where she sat at the head of the table with Deborah to her right, and 2 other board members I recognized from neighborhood events. Greg Patterson was a retired accountant with a perpetually worried expression, and Michelle Torres was a real estate agent who usually seemed more interested in her phone than in HOA business. "Thank you for coming," Deborah began, but Sharon cut her off. "Let's be clear about something," Sharon said, her voice cold. "This board has the authority to set and enforce community standards. We updated the setback requirements for good reason. A 12-foot setback is insufficient for maintaining proper spacing between properties." Rick leaned back in his chair, completely relaxed. "Mrs. Westfield, with all due respect, the reason for the rule change is irrelevant to this situation. My client received written approval for his deck based on the rules in effect at the time he applied. He obtained proper permits, hired licensed contractors, and built the deck exactly as approved. You cannot retroactively apply new rules to a completed approved project. The CC&Rs give this board the authority to modify rules as needed to maintain property values," Sharon insisted. "They do," Rick agreed, "but they don't give you the authority to apply those new rules backward in time. That's not how contract law works, and it's not how HOA covenants work either. The North Carolina Planned Community Act is very clear about this. When a homeowner receives approval for a project and completes it in good faith reliance on that approval, the HOA cannot later claim it's a violation based on subsequently adopted rules." Greg cleared his throat nervously. "I actually wasn't aware that Logan had received prior approval when we voted on the violation notice. Sharon presented it as an unapproved structure." Sharon's face flushed. "The approval was under old rules. The approval was under the rules that existed at the time, which is what matters legally, Rick interrupted. Look, we can do this the easy way or the hard way. The easy way is that the board votes to rescind all violations and fines related to Mr. Callahan's deck, acknowledges that it was built in compliance with the rules in effect at the time, and we all go home. The hard way is that we go to court, a judge rules in our favor, because the law is completely on our side, and the HOA ends up paying not just for its own attorneys but for our attorneys' fees as well. Plus, we'll ask for sanctions for filing a frivolous violation. Michelle finally looked up from her phone. How much are we talking about in legal fees? Our firm's retainer for HOA litigation starts at $15,000, Rick said, and based on the facts of this case, I'm confident a judge would award fees to the prevailing party, which will be my client. I watched the board members exchange glances. Greg looked distinctly uncomfortable. Michelle had put her phone down entirely and was frowning at the documents Rick had brought. Even Deborah, who'd tried to be diplomatic, seemed concerned. Only Sharon remained defiant. This is exactly the kind of intimidation tactics that prevent HOAs from doing their jobs. We have a responsibility to all the homeowners in this community, not just to people who want to do whatever they please. Mrs. Westfield, Rick said, his voice hardening. My client didn't do whatever he pleased. He followed your process exactly. He submitted an application. He waited for approval. He got that approval in writing. He pulled permits. He built according to the approved plans. He did everything right. The only party that has acted improperly here is the HOA, under your leadership. The meeting deteriorated from there. Sharon refused to back down, and after another 30 minutes of circular arguments, Rick and I left with nothing resolved. As we walked to our cars, Rick shook his head. She's going to force this to court. I've seen it before with HOA board members who get tunnel vision. They convince themselves they're protecting the neighborhood and can't admit when they've made a mistake. So what happens now? Now we proceed with litigation. The HOA will hire an attorney, probably spend tens of thousands of dollars, and eventually lose. The question is whether the other board members will figure out how expensive Sharon's stubbornness is going to be before that happens. Over the next 2 months, the legal process ground forward with all the speed of a glacier. The HOA hired a law firm that specialized in representing homeowners associations, a large practice based in uptown Charlotte. Their initial response to our lawsuit was heavy on legal jargon but light on actual defense of the HOA's position. Mostly, they argued that HOAs had broad authority to enforce community standards and that the board had acted within its discretion. Rick filed a motion for summary judgment, arguing that there were no disputed facts and that we were entitled to judgment as a matter of law. The HOA opposed the motion, but their arguments seemed increasingly desperate. They tried to claim that my approval had been conditional and subject to future rule changes, but they couldn't point to any language in the approval documents that said anything like that. They argued that the new setback rules were necessary for safety reasons, but they couldn't explain how a structure that was safe and legal when built had become dangerous 3 months later. Meanwhile, the fines continued to accumulate on paper. By the time we had our hearing on the summary judgment motion in mid-August, the HOA claimed I owed over $40,000 in penalties. They'd also sent another letter threatening to place a lien on my house, which Rick immediately moved to block with a temporary restraining order. The hearing was held in a modern courtroom in the Mecklenburg County Courthouse, with Judge Patricia Rosenberg presiding. She was in her late 50s, with sharp eyes and a no-nonsense demeanor that suggested she had little patience for frivolous arguments. I sat behind Rick at the plaintiff's table while the HOA's attorney, a man named Kenneth Devereaux who wore an expensive suit and carried himself with the confidence of someone who'd won a lot of cases, sat across the aisle. Judge Rosenberg started the hearing by asking each side to summarize their position. Rick stood and laid out our argument clearly and concisely. I had received approval for my deck under the rules that existed at the time. I had built it in exact compliance with that approval and with all applicable building codes. The HOA had subsequently changed the rules and was attempting to apply them retroactively. This was improper as a matter of law, violated basic principles of fairness and due process, and was unsupported by the HOA's own governing documents. Devereaux's response focused heavily on the HOA's authority to adopt and enforce rules. He argued that property owners in planned communities accepted certain restrictions on their property rights in exchange for the benefits of living in a well-maintained neighborhood. He claimed that the board had the discretion to determine what standards were necessary to protect property values, and that courts should defer to that discretion. Judge Rosenberg let him finish, then leaned forward. "Counselor, does your client dispute that Mr. Callahan received written approval for his deck?" "No, Your Honor, but does your client dispute that the approval was granted under setback requirements that allowed a 12-foot setback from the rear property line?" "The approval was granted, Your Honor, but the board subsequently determined that the setback requirements needed to be updated. When did the board make this determination? Devereaux consulted his notes. The new rules were adopted in April of this year. And when was Mr. Callahan's deck completed? According to the county inspection records, the final inspection was completed on May 10th. So the deck was substantially complete, if not entirely complete, when the new rules were adopted. The deck was under construction, yes, Your Honor. Judge Rosenberg sat back. What is your legal authority for the proposition that an HOA can apply newly adopted rules to a structure that was approved under prior rules and already under construction when the new rules were adopted? Devereaux launched into an argument about the broad powers granted to AHOs under their CC&Rs in North Carolina law, but I could see Judge Rosenberg's expression growing increasingly skeptical. She let him talk for about 5 minutes before interrupting. Counselor, I've read the planned community statutes. I've read the case law you cited in your brief. Nothing you've cited supports retroactive application of rule changes to approved, permitted structures. Do you have any case law that actually addresses this specific issue? Your Honor, the board has a fiduciary duty to all homeowners in the community. If a structure doesn't meet current standards, it could affect property values. That's a policy argument, not a legal argument. I'm asking you for case law that says an HOA can do what your client is trying to do here. There was a long pause. Devereaux shuffled through his papers, and I could see him struggling to find an answer that didn't exist. Finally, he said, Your Honor, we believe the board acted within its discretion, and we ask the court to defer to that discretion. The problem, Counselor, is that discretion has limits. An HOA board can't simply ignore approvals it has already granted. If I allowed what your client is attempting, no homeowner could ever rely on an HOA approval. They could spend thousands or tens of thousands of dollars on a project, build it exactly as approved, and then be told it's a violation because the board changed its mind. That's not how contract law works, and it's not how the planned community statutes are intended to function. Judge Rosenberg turned to Rick. Counsel, does your client have any objection to me ruling from the bench? Rick stood. No, Your Honor. We'd welcome a ruling. The judge nodded and pulled her microphone closer. The court finds as follows. The plaintiff, Logan Callahan, submitted an application for architectural review to the defendant HOA in January of this year. That application showed a deck with a 12-foot setback from the rear property line, which complied with the HOA's setback requirements as they existed at that time. The application was approved in writing in February. Mr. Callahan obtained proper county permits and constructed the deck in exact accordance with the approved plans and all applicable building codes. The deck was completed in May. In April, after construction had already begun, the HOA amended its setback requirements to require a 15-foot setback. In June, the HOA notified Mr. Callahan that his deck violated the new requirements and began assessing fines. The issue before this court is whether the HOA can retroactively apply the new setback requirements to a structure that was approved and built under the prior requirements. The answer is no. Basic principles of fairness and due process prohibit retroactive application of new rules to conduct that was lawful when it occurred. Mr. Callahan obtained approval for his deck in good faith, relied on that approval, and expended significant sums of money to construct the deck as approved. He did everything right. The HOA cannot now claim that the deck violates rules that didn't exist when the project was approved and substantially completed. Furthermore, the North Carolina Planned Community Act does not grant HOAs the authority to retroactively apply rule changes. While HOA boards have significant discretion to adopt and enforce reasonable rules, that discretion is not unlimited. It does not extend to invalidating approvals already granted and projects already completed. Accordingly, the court grants the plaintiff's motion for summary judgment. The court declares that the plaintiff's deck was constructed in compliance with applicable HOA rules and does not constitute a violation. The court orders the defendant to vacate all fines and penalties assessed against the plaintiff related to the deck. The court permanently enjoins the defendant from assessing any future fines or penalties related to the deck and from placing any lien on the plaintiff's property based on alleged violations related to the deck. Judge Rosenberg paused and looked directly at Devereaux. Counselor, your client should consider itself fortunate that the plaintiff is not seeking damages for harassment and emotional distress. What the HOA has done here borders on the outrageous. Mr. Callahan followed every rule, obtained every approval, and did everything a responsible homeowner should do. He was then subjected to threats of massive fines and a lien on his property for no valid reason. The board's conduct in this matter has been unreasonable and has wasted both the plaintiff's resources and this court's time. The court further grants the plaintiff's request for attorney's fees and costs pursuant to North Carolina General Statutes Section 47 F.3.1.22. Counsel for plaintiff shall submit an affidavit of fees and costs within 14 days. Any opposition shall be filed within 7 days thereafter." She banged her gavel. "We're adjourned." I felt a wave of relief wash over me, so intense it was almost physical. Rick turned and shook my hand, grinning. That went about as well as it possibly could have. We left the courtroom, and I immediately called Dana, who was just finishing her shift in Seattle. We won. The judge completely sided with us. She told the HOA they couldn't apply the new rules retroactively and ordered them to drop all the fines. "Oh, thank God," Dana said, and I could hear the relief in her voice. "I was so worried they were going to force you to tear down the deck. You worked so hard on it. Not only do I not have to tear it down, but the judge is going to order them to pay our attorney's fees." Rick said it'll probably be around $20,000 by the time he submits his affidavit. "Good. They deserve it for putting you through this." Over the next few weeks, the aftermath of the case played out. Rick submitted his fee affidavit documenting over 60 hours of work at his normal hourly rate, plus court costs and filing fees. The total came to just over $23,000. The HOA's attorney filed a half-hearted objection claiming the fees were excessive, but Judge Rosenberg granted the full amount. The real drama, however, was happening within the HOA itself. I started hearing through neighborhood gossip that several homeowners were furious about the legal fees the HOA had incurred. The association had spent nearly $30,000 on Devereux's firm, plus they now owed me another $23,000 in attorney's fees and costs. That $53,000 hit was going to require a special assessment, meaning every homeowner in Meadowbrook Heights was going to get a bill. I was working in my garage one Saturday afternoon in early September when Greg Patterson knocked on my open garage door. He looked uncomfortable, shifting his weight from foot to foot. "Logan, do you have a minute?" "Sure, Greg. What's up?" I wanted to apologize. I should have asked more questions when Sharon brought the violation to the board. If I'd known you had approval and permits, I never would have voted for the fines. I set down the socket wrench I'd been using. "I appreciate that, Greg. The thing is, there's going to be a special board meeting next week. A bunch of homeowners have signed a petition to recall Sharon from the board. They're angry about the legal fees and the special assessment. I think you should know that there are a lot of people in the neighborhood who think you were treated unfairly. I'm not looking for revenge, Greg. I just wanted to keep my deck." "I understand. But Sharon's not going to let this go easily. She's telling people that you sued the neighborhood, that you're trying to destroy the HOA, that you don't care about property values. It's getting ugly." He was right about that. Over the next week, I received 2 anonymous letters in my mailbox, both calling me selfish and accusing me of costing the neighborhood tens of thousands of dollars. Someone spray-painted "Lassoot" on my driveway in the middle of the night, which I had to clean off before going to work. A neighbor I'd always been friendly with crossed the street to avoid talking to me, but there were also positive contacts. Deborah Morrison stopped by to apologize for the board's handling of the situation. Michelle Torres sent me a text saying she'd voted against the violations, but had been outvoted by Sharon and one other board member who'd since resigned. Several neighbors I didn't know well made a point of saying they thought the HOA had been in the wrong. The special board meeting was held on a Wednesday evening in the community clubhouse, and it was packed. At least 60 homeowners showed up, which was about triple the normal attendance. I went with Dana, who'd flown back to Charlotte for a long weekend specifically to be there for the meeting. Sharon called the meeting to order and immediately tried to move to executive session to discuss legal matters, but several homeowners objected loudly. A man I recognized from the next street over, Marcus Johnson, stood up. "We're here because of how you handled the Callahan situation, Sharon. We all got the special assessment notice. We all know the HOA just got hit with a $50,000 judgment because of decisions you made. We deserve to hear an explanation in public. The board acted to enforce community standards," Sharon said, her voice tight. "Mr. Callahan chose to sue rather than comply with reasonable requirements. He had approval," someone else called out. "The judge said so." The judge sided with a technicality. "It wasn't a technicality," I found myself saying, surprised by the sound of my own voice. Dana squeezed my hand. "I submitted an application. I got approval. I built exactly what was approved. The HOA tried to apply new rules backward in time after I'd already finished building. That's not a technicality. That's the HOA acting inappropriately. You could have simply moved the deck," Sharon shot back. "Instead, you cost this neighborhood thousands of dollars." "The HOA cost this neighborhood thousands of dollars," Rick said from behind me. I hadn't even known he was there. "My client followed every rule. Your board decided to ignore its own approvals and try to enforce rules that didn't exist when his project was completed. When he objected, your board doubled down instead of admitting the mistake. Every dollar spent on legal fees was spent because of the board's decisions, not because of my client." The meeting continued for another 2 hours. Multiple homeowners spoke, most of them critical of Sharon's leadership. The petition to recall her from the board had more than enough signatures to force a vote, and when that vote was held at the end of the meeting, Sharon was removed from the board by a margin of 42-11. She left the clubhouse in furious silence, and I didn't see her at any neighborhood events after that. The HOA elected a new president, a retired engineer named Thomas Brennan who'd lived in Meadowbrook Heights for 15 years. One of his first actions was to send a formal letter of apology to me on behalf of the association, acknowledging that the board had erred in its handling of my deck approval and thanking me for my patience during the resolution of the matter. It was a small gesture, but it meant something. The special assessment to cover the legal fees was painful for the neighborhood. Each of the 120 homes in Meadowbrook Heights got a bill for about $440 to cover the $53,000 hit. I heard grumbling about it for months, but most people seemed to understand that it was the HOA board's fault, not mine. Dana's contract in Seattle ended in November, and she came home for good just before Thanksgiving. We spent that evening sitting on the deck that had caused so much trouble, wrapped in blankets against the cool North Carolina autumn air, drinking wine and watching the sunset. Was it worth it? Dana asked. All the stress and the lawsuit and the neighborhood drama? I thought about it for a moment, looking at the deck I'd planned so carefully and built with my own hands. Yeah, it was. Not because of the deck itself, really, but because it was the right thing to do. If I'd just given in and torn it down, Sharon would have done the same thing to the next person who came along. Sometimes you have to stand up to people who abuse their authority. Very philosophical, Dana said, leaning her head on my shoulder. But also, you really didn't want to tear down this deck. I laughed. That too. The following spring, the new HOA board formally adopted a policy stating that any rule changes would apply only to projects submitted after the effective date of the change. Projects that had been approved under prior rules would be grandfathered in, even if construction was ongoing when the rules changed. Thomas Brennan personally called me to let me know about the policy and to thank me for forcing the board to think more carefully about how it handled approvals and rule changes. You did the neighborhood a favor, even if it didn't feel like it at the time, he said. We needed a wake-up call about how we were operating. The board was getting too heavy-handed, and nobody was pushing back. Your case made us rethink a lot of things. Sharon moved out of Meadowbrook Heights about a year after the recall vote. I heard she'd bought a condo downtown, which seemed appropriate. She'd never really fit into the neighborhood's more relaxed atmosphere. She'd wanted to run a tight ship, but she'd mistaken rigidity for order and control for leadership. As for me, I became unexpectedly involved in HOA governance. Several neighbors asked me to run for the board in the next regular election, arguing that I understood the importance of following proper procedures and treating homeowners fairly. I was reluctant at first, but Dana encouraged me. You could make sure this doesn't happen to anyone else, she said, and you'd be good at it. I ended up winning a board seat and serving for 3 years. During that time, we streamlined the architectural review process, created clear timelines for approval decisions, and established an appeals procedure so homeowners had recourse if they disagreed with a board decision. We also worked to improve communication with the neighborhood, sending out regular newsletters and holding quarterly town halls where anyone could raise concerns. The deck itself became something of a neighborhood legend. People would point it out to new residents and tell the story of how the HOA tried to make me tear it down and ended up losing in court. It was a reminder that homeowners associations, for all their power, aren't above the law and can't simply change the rules whenever they feel like it. Rick and I remained close friends, and he'd occasionally joke that I'd given him one of his easiest wins ever. I should send Sharon a thank you card, he'd say. She made me look like a genius in court when all I really did was point out the obvious. But there was something deeper that came out of the whole experience, something I thought about often during my time on the HOA board. Power, even in something as mundane as a neighborhood association, can corrupt if there aren't checks and balances. Sharon had convinced herself that she was protecting the neighborhood, but what she was really doing was imposing her will without regard for fairness or due process. She'd forgotten, or maybe never understood, that HOA board members are supposed to serve the homeowners, not rule over them. The incident also taught me about the importance of documentation. If I hadn't kept every email, every approval letter, every permit, I might not have been able to prove my case so conclusively. Rick always said that the key to winning any legal dispute is having the facts clearly on your side. And I'd certainly had that advantage. Years later, long after the drama had faded and Sharon was just a footnote in neighborhood history, Dana and I would still spend summer evenings on that deck. We'd grill steaks, invite friends over, watch our eventual kids play in the yard. The deck had become exactly what I'd envisioned when I first planned it, a place to relax, to gather, to enjoy our home, and every once in a while, when someone new to the neighborhood would ask about it, I'd tell them the story, not to gloat or to relitigate old grievances, but as a reminder that sometimes doing the right thing requires standing up to people who think their authority is absolute. Sometimes you have to fight, even when it would be easier to give in. The deck stood 12 feet from my rear property line, exactly where it was always supposed to be. It was built to code, constructed with quality materials, and approved by every relevant authority. The fact that I'd had to go to court to defend it said more about the HOA's dysfunction than it did about anything I'd done wrong. In the end, Judge Rosenberg's ruling became something of a local precedent. Rick told me that he'd cited it in 2 other cases involving retroactive HOA enforcement, and both times the opposing attorneys had backed down rather than face a similar loss. The case was even mentioned in a North Carolina Bar Association article about HOA law, using it as an example of the limits of HOA authority. For me personally, the whole experience had been exhausting and stressful and maddening, but it had also been clarifying. I'd learned that I was willing to fight when I knew I was right, even when it would have been easier to surrender. I'd learned that having good documentation and a good attorney could make all the difference. And I'd learned that sometimes the most important battles aren't over huge, world-changing issues but over simple matters of fairness and respect. Sharon had tried to use her position to force me to tear down something I'd built legally and with proper approval. She'd been convinced of her own righteousness and unwilling to admit error. She'd cost the neighborhood tens of thousands of dollars rather than simply acknowledge that the board had made a mistake. But the system had worked eventually. The courts had intervened. The homeowners had exercised their right to recall a board member who'd acted unreasonably. New leadership had learned from the mistakes of the old. The neighborhood had moved forward, and my deck, that 12-foot setback deck that had caused so much controversy, stood as a quiet testament to the principle that approval granted in good faith cannot be retroactively revoked. It was just composite boards and support beams and railings. But it represented something more important: the idea that people who follow the rules deserve to be protected, even from the very authorities that made those rules. Dana and I eventually did those other renovations we'd been planning. We updated the kitchen, refinished the hardwood floors, and added a bathroom. Every time I made sure to submit proper applications to the HOA, get everything in writing, and keep meticulous records. I never had another problem, but I also never took approval for granted. Thomas Brennan served as HOA president for 5 years before stepping down, and the board remained reasonable and responsive during his tenure and after. The neighborhood thrived. Property values increased. People took pride in their homes and in the community. All the things Sharon had claimed to be protecting were actually enhanced once the HOA stopped trying to micromanage every detail and started trusting homeowners to make reasonable decisions. Looking back on it all, I realized that the fight over the deck had never really been about the deck itself. It had been about whether someone in a position of minor authority could arbitrarily change the rules and force compliance through threats and intimidation. It had been about whether homeowners had rights that even their HOA had to respect. It had been about fairness, process, and the rule of law, even in something as prosaic as a suburban homeowners association. The answer, as Judge Rosenberg had made clear, was that homeowners do have rights. Approvals do mean something. Rules can't be changed retroactively to punish people for conduct that was legal when it occurred. These principles might seem obvious, but they're worth fighting for when someone tries to ignore them. I never regretted building that deck, and I never regretted fighting to keep it. Sometimes the principled path is the harder one, but it's also the path that lets you sleep at night. And sometimes when the evening light hits just right and I'm sitting there with a cold drink in my hand, I can forget all the legal drama and neighborhood politics and just enjoy what I built. A simple outdoor space, 12 feet from my property line, exactly where it belongs.